Have you ever heard of Halsburys Law of England? Ever heard of it? I hadn't heard of it, to be honest with you, till somebody got in touch with me recently. I think that's the advantages of being on YouTube. You put your head above the parapet and people get in touch with all sorts of bits and bobs, useful information. And all of a sudden, through the door came, oh, what's this? No, actually, it came by email, which was very nice. Or was it on a WhatsApp? Doesn't really matter. It came to me. Somebody said, have you heard of Halsburys Law of England? I thought, no. So what? So I had to go and look it up quickly. And let's have a look and see what it says here. This is on that beloved Wikipedia site that must be true. The important bit is here. And you'll see why I'm mentioning this, because Halsburys Law of England is a uniquely comprehensive encyclopedia of law and provides the only complete narrative statement of law in England and Wales. Provides the only complete narrative statement of law in England and Wales. That's significant. Do you want to see a picture of the inside cover? Here we go. Here's a picture of the inside cover. It's a bit dim. Sorry about that. Can't do with that. The complete statement of the whole law of England. This is from 1907. There are updated versions of it. So what, you might say? All right, then. All right. What about this little piece of wisdom that was passed over? Not that one, not that one, not that one. There it is. Administrative courts, unlawful, according to Halsburys Law. Remember, we said that Halsburys Law was provides the only complete narrative statement of the law in England, a uniquely comprehensive encyclopedia. There it is. This is it. Halsburys Law states administrative courts, i.e. your magistrates' courts and things like that, and it says the councils up and down the land, and the CSA, the Child Support Agency, might want to read this. So what does it say then? How does it prove it? It says here, I'll read it to you because it's text and you can come and try and read it with me if you like. The law, it says, is absolutely clear on this subject. There is no, capital letters, no authority for administrative courts in this country, and no act can be passed to legitimise them because of the constitutional restraints placed upon Her Majesty at her coronation. Okay, so that's talking about the Queen. This came out, I believe, in 2011. So this observation, 2011, is fairly recently put out, which means it could still be on the case. I know we've had another coronation, but the old King, Charlie Boy, did do the oath and what have you, and you'll see where that comes in. So bear with me on this. Let's just see. This might turn the tables a little bit in our favour. The collection of revenue by such means is extortion. We're talking here about administrative collections, like the council tax, for example. And extortion has been found reprehensible since ancient times. Separations of powers today, in the year 2011, we find, for example, that the council tax regulations, the billing authority, the prosecuting authority, and the enforcement authority are all vested in the same body. The same bodies even purport to issue their own legal documents by tacit agreement with the courts. In our system of common law, the rule of law demands that we have a separation of powers. Today, the powers are not separated. The executive is not a distinct freestanding leg of the tripod. The executive now emerges directly from within the elected chamber of the legislature, where previously it emanated directly from the monarch. That leads to constitutional confusion because the executive has seized and misuses Parliament's democratic credentials for its own destructive purposes. Fortunately, we have something to which we can turn to preserve our ancient laws and freedoms. We have the oath that Her Majesty the Queen, and presumably His Majesty the King now, took at his or her coronation, by which he or she is solemnly bound and from which no one in England, Wales and Scotland has released her. At her coronation, the Queen swore to govern us according to our respective laws and customs. Certainly among our reported customs is precisely that invaluable and widely admired tri-party division of the powers. The judiciary is part and parcel of our customary system of internal sovereignty. The Queen in Parliament. It is one of the three separate but symbiotic powers, and it is a capricious and self-serving contention that it should not have the power to preserve the authority of the legislature over the executive. It is a constitutional principle that the assent of the Queen and Parliament is prerequisite to the establishment of a court which can operate a system of administrative law in Her Majesty's courts in England. This was confirmed by Lord Denning during the debates on the European Communities Amendment Bill on 8th of October 1986. There is our judicial system deriving from the Crown as the source and fountain of justice. No court can be set up in England. No court can exist in England except by the authority of the Queen and Parliament. That has been so ever since the Bill of Rights. There it is, in black and white, administrative courts unlawful. So there's a bit of a problem then, it would seem, would it not, with courts, administrative courts, people being taken to magistrate court and being billed by courts, by the council, which are not proper real courts. I'd be interested in your thoughts on the courts and see what you make of that. Because maybe, just maybe, and I can't say that I'm a lawyer or anything like that, but maybe, just maybe, there is something that will help people in which, when you say have an energy bill, in which they're saying, well, we're going to come in and force you to have a smart meter, or we're going to force you to go at 20 miles an hour, or we're going to come in and take your wood-burning stove. Just maybe they can't do this. Maybe they can't enforce an authoritative court of this, an administrative court like this, or we're going to come and seize your child. Maybe they can't do this. I'd be interested in what you think. Halsburys Law, ladies and gentlemen. It's amazing what gets passed to you. Absolutely amazing. And I hope you're frothing with excitement as I am. Let's hope one's wishes are not dashed. By the way, that bit of paper I referred to earlier came in the post. Interesting. Let me just read this to you. It's quite a fascinating little story as a by the way. It says here, in 1983 at Bow Street Magistrates Court, a certain Charles Linton was fined £500 for attempting soliciting in the city toilets. The police notes were later to disappear along with several prior warnings. Charles Linton, by the way, was well known at university as Miranda, as a promiscuous cross-dresser who played the guitar badly. And just as a matter of interest, purely by circumstance, Charles Linton are the middle names of one Tony Blair. Anthony Charles Linton Blair. Couldn't possibly be the same person, could it? Couldn't possibly refer to an ex-Prime Minister, Sir Anthony Charles Linton Blair, born on the 6th of May 1953, a politician who served as Prime Minister in the United Kingdom from 1997 to 2007, the leader of the Labour Party from 1994 to 2007. Couldn't possibly be. But it's amazing what is passed to you, is it not, when you're on YouTube? Go and have a look up Halsburys Law. Are administrative courts unlawful? Could be the cat among the pigeons there.